State versus B.J. Brown. Are we ready? Stay ready.
State's ready, Your Honor.
If it's ready, Your Honor, I have one small matter on that case, if I may, just so I don't forget, there's an order for the indigent transcript for the case, Your Honor.
Mr. Spratt, I have signed this order. You want me to just hand it to the clerk?
Yes, Your Honor. Thank you.
All right. We are ready then on the State versus B.J. Brown sentencing hearing. State may call your first witness.
Oh, Darrel, Tiebor, Your Honor. Would you state your name for the court, please, sir?
Officer Darrel Tiebor,
And would you spell your first and last name?
Darrell, last name's Tiebor.
All right. And where are you employed?
The City of Erin Police Department.
All right. And we'll be kind of brief with the description. But you were working for the City of Erin when this incident happened, June 27th of 2022. Is that right?
Yes, sir.
All right. And were you on patrol that day?
That's correct.
And if you will, just give the court a brief description of the incident that happened that day.
I was stationary on Highway 49, East Main Street, that area. At Computer One, monitoring traffic. Saw a vehicle turn from 13 South, turn on to westbound onto East Main Street. As the vehicle passed in front of me, didn't see a license plate or any tag on the back of the vehicle. At that point, the vehicle turned north onto Highway 149, pulled behind the vehicle and conducted a traffic stop. As I was giving information to dispatch, the individual stepped outside of the vehicle, started shouting at me. I asked him to return to his car. When he stepped back inside of his car, he then stepped back out of the car with AR-15 and proceeded to fire multiple rounds at my unit.
And were you hit with some of those rounds?
That's correct. As I was returning fire, I was struck once in my upper bicep area and then once in the elbow.
All right. And then after that, did Mr. Brown run off?
That's correct.
So if you would describe kind of your injuries for the court.
As I stated, I was while I was returning fire, I had one bullet enter upper bicep, left of my left arm. It then hit my clavicle, fractured my clavicle, redirected toward my neck, and then exited a couple inches from my neck.
Right. And obviously you went to the hospital for that?
That's correct. I was life flighted to Vanderbilt.
Right. How long were you in the hospital?
I got out probably about 3 p.m. the next day.
And do you still have some of that shrapnel and maybe even a bullet in your body today?
That's correct. I have a bunch of copper fragments all throughout my shoulder and still have the bullet that entered my elbow. Bullet still in my elbow.
And do those injuries, do they cause you any trouble today, or are they pretty much healed?
They've healed up, but I still feel from time to time slight discomfort and pain from shrapnel in there.
And what about like any physical or emotional injuries or things that you were going through when this happened? Would you describe any of that for the court that you may have had?
I mean, I left with, not just physical scars and again from the slight discomfort from the shrapnel, but emotionally, I mean, that's something that sticks with you for the rest of your life, I oftentimes think back to it a lot of times, or I've noticed sometimes I'll be dreaming about it, wake up middle of the night.
And for Mr. Brown's convictions, what do you feel would be the just punishment for what he's done?
100% life without parole.
Sir, questions, Judge?
Mr. Spratt, do you have any questions?
No questions, Your Honor.
Thank you, officer. You may stand down. Have a seat in the courtroom if you'd like. They may call your next witness.
Oh, Wendy James, Your Honor. Would you state your name for the court, please, ma'am?
Wendy James,
And would you spell your first and last name?
Wendyjames.
And Ms. James, how are you employed?
I'm employed with the Department of Correction, probation officer.
And as part of your duties, do you put together pre-sentence reports?
Yes, sir.
And did you put one together in this case?
Yes, I did.
There you go. You recognize what I've handed you there, Ms. James?
Yes, I do.
And what is that?
It's the pre-sentence investigation report.
As part of that process of putting this report together, what do you do?
I do a background search and I speak with the defendant in the case in most situations about their education, employment, criminal history, and things like that.
Okay. And do you also collect documents from the court as far as indictments and agency statements, that kind of thing?
Yes,
All that goes into your report as well?
yes.
Okay. If I could direct your attention to page 6 of your report. And is that the prior record of Mr. Brown?
Yes, it is.
And under the first one there, it appears to be a marijuana conviction where he was given a 36-month supervised probation sentence. Is that accurate?
The 5/9/19.
The one above that, the offense date of 8/28/2020.
36 months suspended probation with 2 years active and 1 year inactive probation.
Yes, ma'am. Okay. And that was out of the state of Louisiana?
Yes,
And the docket number for that was 21 CR 32. Is that right?
yes.
Now, the document that I've just handed you there, Ms. James, would you turn to the third page? There's a big paragraph in the middle of that third page. Does that also reflect in the middle there that he was found guilty of this marijuana charge, which you have in your pre-sentence report?
Yes,
All right. And is that the same docket number that you have there in your pre-sentence report?
yes, it is.
Your Honor, would ask to make that the state's first exhibit.
You marked it as Exhibit 1.
And then, Ms. James, just below that on your pre-sentence report, you have a case offense date of 5/9/2019. Do you see that?
Yes,
And what was that conviction for?
it was meth manufacture, delivery, seller, possession.
And what was the docket number in that case?
2021 CR 31.
I'm gonna hand you another document here. The document that I've just handed you, is that also the docket number 21 CR, or 2021 CR 31?
Yes, it is.
All right, if you would turn to the third page of that document. The first big paragraph, about halfway down, or a little under halfway down, do you see where he was convicted of this methamphetamine charge
Yes,
with the same probated sentence that was on the prior conviction?
yes.
Your Honor, would ask to make that the next exhibit.
Marked as Exhibit 2.
And then, Ms. James, if I could direct your attention to page 7 of your pre-sentence report. And this time, the second one down, the offense date of 7/26/2014. What was that conviction for?
Burglary, first degree.
All right, what was the docket number?
0521964.
And if I could direct your attention to page 5 of this document.
Okay.
On 9/9/2015, do you see the paragraph that I'm on there? The fourth,
What page are you on?
the pages aren't numbered, Your Honor, but it's the 5th page.
It is
said-
at the top. If you look at the
It
top
says page
left-hand
3 at the
corner.
top, Your Honor.
Yes,
Are you looking at the conviction?
This is a separate conviction we haven't
I'm
haven't
sorry,
introduced
okay.
yet, Your Honor.
I was looking at the pre-sentence report. I apologize.
I apologize, Judge. Ms. James, do you see the 9/9/2015 conviction
yes,
there?
I do.
All right, and was that for burglary?
And it's the 9/9/2015?
Yes, ma'am. Let me scratch that. Let me direct your attention to page 2 first. This one's a little different than the other two. On page 2, do you see count 1? The paragraph just above count 2
Is it the page 2, the documented page 2?
looks
or-
like this. Second page of the stapled document. The second paragraph there, is that a burglary charge that Mr. Brown was charged with?
Yes,
Burglary of a
it is.
vehicle?
Yes, it is.
And back on page 5 of the document, was he convicted there, received a 3-year sentence?
Yes.
All right. Your Honor, would ask to make that the next exhibit.
There's 3.
All right, Ms. James, back to the pre-sentence report, turning your attention to page number 10. In your summary, the last line of your summary, it says that Mr. Brown refused to participate in an interview with the investigating officer. Do you attempt to interview the defendants as part of this report?
I contacted the prison and they had him sign a refusal because he did not want to participate in the interview.
Okay. Do you also typically do a risk and needs assessment? I think it's the strong R assessment you'll call it.
Yes, that's part of the interview
Okay.
process.
And Mr. Brown didn't want to fill that out either?
No,
Right. Also, did you get a victim impact statement from Officer Tiebor?
I did.
All right, and that's what we see there at the end of the report.
Yes, it is.
All right, and Officer Tiebor, as he had testified to today, I believe in sentence number 4, or in paragraph number 14 or question number 14, he asked that the judge sentence Mr. Brown to life without parole.
Yes.
Your Honor, we'd ask to make a copy of the pre-sentence report, the state's next exhibit.
I have a copy of, let's make it original, which was filed. Let's just make this, I have 2 copies. I have the original and I have a copy, so I'm gonna make the copy that.
Yes, Your Honor. And Ms. James, we won't go through them all individually, but did you also, going through Mr. Brown's criminal history, did you find several convictions for misdemeanor offense, including assault, theft, resisting arrest, as is documented in your report?
Yes, there were several.
Your Honor, we'd pass the witness at this time.
Mr. Spratt?
Afternoon, Ms. James. Are you, where do you get these background checks from? What do you do in order to get that information?
Well, there's an NCIC run. In this case, I had to contact the courts in Louisiana to get a lot of the information. A lot of the information was not returned that I requested. I contacted the DA's office and I got their report where the court actually had said they came to Louisiana and got all of the documentation. So I contacted them to get the documentation.
So a lot of that information came from the district attorney's office in New Orleans then?
I suppose so. I got it from our district attorney's office, but it came from, yes, the
Okay.
district attorney's office.
And the marijuana charge that you testified to, are you aware of the nature of that marijuana charge?
Can you tell me what page it's on?
I'm sorry, it was Exhibit 1. I think it was page 7. No, that would have been, I think it's page 6. The 8/28/20. Would have been the offense date, or at least that's what this shows.
Okay, that's the synthetic marijuana.
Okay. So you don't know whether that was real marijuana or whether it was just synthetic marijuana? It says it was synthetic, right?
Yes, I only know
Okay.
he got 36 months
Okay.
probation.
All right, but you have no idea, you're not familiar with the nature of that. You don't know Louisiana law, do you?
No, I don't.
Okay. And you don't know whether or not that would be legal here or not, do you?
No.
Okay. All right. And the right below that, the methamphetamine charge, you don't know, are you aware how many different methamphetamine charges there are in the state of Tennessee?
No, I'm not.
Okay. There's several. Can we agree on that?
Yes.
Okay. And you don't know the nature of what this methamphetamine charge is right here, do you?
No.
You don't know how much was involved or anything like that?
No.
Okay. All right. Those are my questions.
Redirect?
Oh, Your Honor.
Thank you, ma'am. You may step down and have a seat in the courtroom. Mr. Turnbull, you may call your next witness.
I'd like to go ahead and make a collective exhibit of several more certified convictions.
You want to make this exhibit 4 collective?
Yes, please, Your Honor.
Exhibit 4 was this pre-sentence report, correct? Thank you. Thank you.
And Your Honor, just for the record, there's one case of resisting an officer, another case domestic assault, simple criminal damage to property, resisting an officer, drug paraphernalia, resisting an officer, what we would contend is simple possession of marijuana, and resisting an officer, domestic assault, simple battery, and then another resisting an officer, Your Honor.
All right, those are marked as Exhibit 4 collective. Mr. Turnbull, you may call your next witness. Exhibit 5 collective. Keep repeating it until I get it right.
State calls Alex Brodhag. Good afternoon. Will you state your full name for the court, please?
Good afternoon. My full name is Alex Brodhag.
Thank you. Will you spell your first and last name?
My first name is Alex. My last name Brodhag.
And Agent Brodhag, where are you employed?
I'm employed by the Tennessee Bureau of Investigation. I work in their crime lab in Nashville in the firearms examination section of the lab.
Agent Brodhag, you have previously testified at the trial in this case, State versus B.J. Brown. Is that correct?
Yes, sir, that's correct.
At that time, you were recognized and entered as an expert witness in the areas of firearm examination. Is that correct?
Yes, sir, that's correct.
Thank you. And through your testimony, several lab reports were entered at the trial. Is that correct?
Yes, sir.
All right. And today, Agent Brodhag, I'd like to turn your attention to a report issued on May the 22nd of 2023.
Yes, I have a copy here.
Judge, I'm going to object to this report.
On what basis?
Relevance, this is a report, I believe, that's where Agent Brodhag had done some, I think he had analyzed some shell cartridges from Louisiana. And I just don't think this is relevant to sentencing at all here today. It's clearly what we're trying to do is go back into this Louisiana case, which is what's been going on the entire time. So I don't see the need for it, the relevance for it as to this sentencing right here today. Again, I filed one motion, we had one order at the outset of this entire case, and this whole case has been about Louisiana, and that's what we're doing again here today.
Judge, first of all, Mr. Spratt's order, the order that the court entered regarding Louisiana was applicable only to the trial, not to the sentencing hearing. Should I go forward with my?
Sentencing hearings allow for the introduction of material that would otherwise not be admissible in a trial before a jury. And for that reason, the evidentiary requirements of a sentencing hearing are much different than they are at trial. And therefore, any other evidence that might weigh on the court's decision in sentencing is admissible unless there's some reason it can't be. And I find that this is admissible evidence, and therefore overrule your objection. The objection is noted in the record and it is overruled.
Agent Brodhag, let me again turn your attention to the report dated May 22nd, 2023. And in that report, you have listed as an exhibit, TBI exhibit 018A, which is a rifle 5.56 by 45, serial number SX46781. That rifle has been previously entered as an exhibit in this trial. Is that
To
correct?
the leading, Your Honor.
Judge,
Well, have we qualified him as an expert for purposes of the sentencing hearing yet?
not yet, Your Honor.
Sustained, don't leave the witness.
Agent Brodhag, Although you have been previously qualified as an expert in a trial, let's go back through some of your training and background again.
Sure.
Can you go through some of that with us, please?
I have a Bachelor of Science degree in Forensic Chemistry from Ohio University. I began my career with the TBI in August of 1998. Initially, I worked in the drug chemistry section and also fire debris. But then in October of 2002, I had an opportunity to transfer into the firearms examination section of the lab. At that time, I underwent 2 years of on-the-job training. And during that 2-year period, I worked under the supervision and guidance of a firearms examiner who at that time had over 20 years of experience in the field. As part of my training, he had me spend hundreds of hours looking through the comparison microscope at fired bullets and cartridge cases. And this training enabled me to recognize those markings with which I could pair up a bullet or a cartridge case to a particular firearm.
Agent Brodhag, approximately how many times have you been qualified as a firearms examiner in the courts in the state of Tennessee?
Over 100 times.
Were you qualified as an expert in this court, in this trial, State versus B.J. Brown?
Yes, a previous trial.
Yes. Your Honor, at this time, I would tender Agent Brodhag as an expert in firearms examination.
Court finds that he is qualified as an expert in firearms examination. He will be qualified as that expert.
Agent Brodhag, in the trial, an exhibit was the rifle with serial number SX46781 was moved as an exhibit in the trial. Is that right?
That's correct.
Okay. What comparisons did you do with this rifle?
With the previous case or this
The
particular?
rifle here listed in your lab report.
Previous comparisons?
Yes.
Previously, I compared cartridge cases that were collected from the scene here in Tennessee. I examined those cartridge cases in conjunction with test-fired cartridge cases from the rifle that was submitted as evidence. That's TBI Exhibit 18A.
Okay. So there were some shell casings in Tennessee that you compared to the rifle.
Yes, sir, there were 14.
Did you compare some additional shell casings?
I did, down in New Orleans.
Okay. How were you able to compare shell casings in New Orleans?
Well, they flew us down, the TBI flew us down to New Orleans on May the 15th this past year. We went to the New Orleans crime lab, and they had some cartridge cases that were collected at the scene of a homicide there. I examined those in conjunction with the test-fired cartridge cases from this rifle, TBI Exhibit 18A.
Okay. And what did the examination result?
On the basis of that comparison, I determined that the 5 cartridge cases in the New Orleans case had been chambered in and extracted from the rifle in TBI Exhibit 18A.
So the rifle casings in New Orleans had been chambered in the same rifle that they kept from as the casings found in Tennessee.
Chambered in and extracted from.
Chambered in and extracted. All right. And is that what is reflected in your lab report dated May 22nd, 2023?
Yes, sir.
May I approach the witness, Your Honor?
You may.
Can you identify this document, please?
This is a copy of the report I issued on the basis of my examination of the evidence.
Your Honor, I'd move the copy of this lab report as the state's exhibit number 6.
Be marked as Exhibit 6.
Pass the witness.
Mr. Spratt, you have questions?
Brodhag, when you went to Louisiana, who else went with you?
Denver Hall, Special Agent Denver Hall.
Denver Home?
Hall.
Hall, I'm sorry, I don't hear very well. What does Special Agent Hall do?
His job is to verify my casework. Everything that's done in the TBI crime lab is verified by a second examiner. So he accompanied me to look at under the comparison scope to see if he agreed with my results.
Okay, but he's still within the purview of firearms expert, right? No other, what I'm asking is no other experts went to Louisiana with you?
No, just,
Okay. Firearms experts, right?
yes.
Okay. Those are my questions.
Can you redirect? Thank you, Agent. You may be excused and you may be released, or you may hang around. They may call your next witness.
Thank you.
State called Taylor Looney. Will you state your full name for the court, please?
Taylor Looney.
And will you spell your first and last name?
Taylorlooney.
Agent Looney, where are you employed?
At the Tennessee Bureau of Investigation.
And Agent, were you assigned to investigate this particular case,
I
State
was.
versus B.J. Brown?
Yes, sir.
And do you remember the first day that you were called out on this assignment?
I do.
What was that?
Oh, the date. Do you believe June 27th of 2022?
Okay, and what county did you respond to?
Houston County.
What happened when you got to Houston County?
I arrived on scene to a plethora of law enforcement officers and a scene there at McCaskill's construction where a shooting had occurred involving a police officer.
Okay. And you previously testified at the trial in State versus B.J. Brown?
Yes, sir.
So I'm not going to go through all of your testimony again, but at some point, was Mr. B.J. Brown arrested?
He was.
And did you interview the defendant, B.J. Brown?
I did.
And at the previous trial in this matter, was a portion of your interview played?
It was.
Was a portion of the interview of the defendant redacted and not played?
It was.
And why was that?
Due to instances that were talked about in the interview that occurred prior to the shooting that I was called to investigate.
And what instance is that?
That was a homicide that occurred in New Orleans.
All right.
I'm going to renew the objection to relevance again, Your Honor.
Same ruling is sentencing is open to consideration of other factors. So clearly, as was pointed out, these prior convictions of the defendant were kept from the jury at the time of their consideration because it was not properly admissible. But they are admissible on the issue of sentencing. Same thing with any prior bad conduct as well. So overrule the objection.
And Agent Looney, at some point in this interview, did you show the defendant a video from New Orleans?
I did.
How did you get a video?
I was in contact with the detective investigating the homicide out of New Orleans, and we spoke on the phone, and he sent a copy of the video to me.
And you showed the video to the defendant?
That's correct.
What is the video of?
It's a video of Cassandra Jones being shot in New Orleans.
Okay. And after you showed the video to the defendant, did you ask him some questions about it?
I did.
And do you have a copy of that video, that redacted portion that we did not play at trial here today?
Yes, sir.
All right, if I could draw your attention, actually, this is going to be audio only.
I tell you what I'm gonna do.
Audio only.
I'm gonna show you something. You know how we told you there's video surveillance, people video?
And, Your Honor, may I approach the court?
You may.
I mean, the witness.
I tell you what I'm gonna do. I'm gonna show you something. You know how we told you there's video surveillance, people videoing what happened?
Yeah, let me see.
Okay, I'm gonna show you.
Bro, ladies and got fucking shot outside my crib, bro.
Okay, Agent Looney, we have a transcript for you to kind of follow along with.
Yes, sir.
At this point, are you showing him the video?
Yes, sir.
Is that what we can hear in the background?
That's correct.
All right, thank you.
And that's Cassandra?
Yeah, that's Cassandra. After she's already been shot, pleading for her life. And here you come, walking right here in the same outfit you said you were wearing.
I just got one gray. I got black. Black. I had blue jeans on.
Here you are. You walk up to her. She's laying there. You raise that rifle, and you shot her 2 more times.
Oh my fucking God, bro.
You know that rifle is the same rifle that you had out here.
It's not the same rifle.
We've recovered the rifle, okay?
No,
We have the rifle.
you're trying to, that's what I'm trying to say. You're trying to swap up on me.
I'm not swapping stories. I just want the truth from you, okay?
You just said you didn't have the rifle.
We asked where it's at.
You just, see, you can't play me green. You can't play me green.
Look, man. The shoes in the video, the orange Nike shoes, the same shoes that we got out of the shed that yesterday that you were in there, the soaking wet shoes that you had on from when you were in the creek, okay? I'm telling you, man, just be straight with me, okay? I want you to know I'm not BSing you, okay?
All right?
Okay, just be straight with me, okay? Tell me what happened.
Tell you what happened with what?
Tell me what happened with Cassandra in New Orleans.
All right. Me and Cassandra lived together. We left together in New Orleans, 1402D. We left together.
Okay.
We've been staying together 9 years.
Mm-hmm.
Been staying together 9 years. She checked me out of 77,000 and tried to leave me.
Okay.
Take all my stuff, all my clothes, all my stuff. She checked me out of 77,000.
When did she try to take your, was it cash that you had or?
Yes, I had 77,000.
Okay, in y'all's apartment, I guess?
Yes.
Okay, why did she want to take your money?
She been checking me.
Okay,
It's just that just
yeah.
she hit all this, I just lost it.
So you were staying with her Monday,
Been staying.
Sunday, okay, so you were with her in New Orleans Sunday night,
But-
Monday,
And with her.
then with her, you lived with her,
together. I got
okay,
keys to the house.
All
The
right.
keys is on my car chain.
okay, on the key ring that was in the car, okay, all right. So what led up to the shooting? What happened?
I wanted my money.
You wanted your money. Where was she at when she was down? I mean, who was she with, talking to some people down there? Where were you at?
I just wanted my money.
Did y'all have like an argument or something before?
I went inside.
Where?
I went inside, home. I went inside, asked for my money.
Okay,
She won't give it to me.
okay. And so,
I've been begging for my money. I've been begging for my money since Sunday night.
okay. And so when,
I went home Monday. She won't give it to me.
what
I
happened?
slept on Monday. I lived with her. We lived together 9 years. All my clothes, shoes, everything is in the house.
Is in that house?
Everything. We've been together.
Yeah. So you talk to her, you tell her you want the money on Sunday, you come back.
Told her I wanted my money. Monday, kept calling her on my money.
Okay,
She kept telling me she was gonna leave me. For a new man.
okay.
Then she gonna call my probation officer, tell my probation officer.
Try to violate you, get you put back in jail?
And she was going to jail her life for my money. And I just lost it.
You see what I mean whenever I say tell me what your side of the story is and what really happened?
I
Do you
just
think
lost it.
any normal person wouldn't lose their stuff? You know what I mean? I'm just saying, maybe not, you know what I mean? Some people make bad decisions, but do you realize, it makes sense now, right? That video, you watch that video, you know what it looks like? Cold-blooded murder. But what you're telling me, it puts the story together. It helps understand why what happened, you know? The woman's taking your money from you. She's leaving you for another man.
She's not leaving, that's what she was telling me.
Right, well, she's telling you she's gonna leave you for another man. She's gonna call your probation officer and violate you and get you thrown back in jail and then spend your money that she took from you. So tell me, so what led up to the shoot? Like, I mean, you said you lost it, right?
I just wanted my money.
Right.
I wanted my money.
So,
I didn't want to shoot her. I just wanted my money.
okay, well, what led up, what ended up happening? Why did you ultimately shoot her?
She don't give me my money.
Okay.
I kept begging for it. Worked my ass off for that.
Okay.
I worked my ass off for that money. I saved that money. I worked my ass off for that.
Right.
And I know she wouldn't lie about what she was telling me.
About what? What part?
I put me in jail.
What was she gonna violate you for? Drugs or something, drug use or something like that, or?
Just anything.
Okay,
I wanted my money.
yeah,
I wanted my money.
okay. So, when you went up there and you shot her, so that's just a portion of the video, right? How many times did you shoot her, do you remember?
3 times. The first time I shot her, I just wanted my money. That's why I walked back to ask her, where's my money? Just give me the money and I'm gonna leave.
Okay, so the first time you shot her in the leg, not trying to kill her, you just wanted your money.
She told me she's not giving it, she don't have it.
Okay. And so then you shot her, do you remember where you shot her after you shot her in the leg? Okay. So I get what I'm being told in other I wasn't lying to you about it. That's just one video, right, that I was sent, right? So there's other what I'm hearing is that maybe a couple of shots, walk away, come back, a couple more shots, and then that video that I saw was another time that you walked up and shot her again.
Until asking for my money.
Were you trying to, but did you want to kill her?
My money.
Okay.
Was she saying anything about your money?
She actually don't have it.
After you shot her in the leg, was she saying anything? Was she yelling anything?
Yes.
What was she saying? I couldn't hear.
Yes, she loved me. I tell her that I love her. I just want my money.
And Agent Looney, was that recording part of your confession
Yes, sir.
taken from Mr. Brown?
That's correct.
All right, at this time, I'll move a copy of this interview as the state's next exhibit. I believe that'll be number 7. Agent Looney, did you hear the defendant say how many times he shot Miss Cassandra Jones?
Yes, sir.
How many times?
3 times.
And you literally showed him the video during this interview?
That's correct.
And do you have a copy of the video with you today?
Yes, sir.
If I could have that queued up, please.
Crouch, are you wanting this transcript to be also made an exhibit?
Yes, I would also ask that the transcript be made the next exhibit.
I'll use this copy that I have marked. Transcript is the next exhibit. That would be 8.
I'm on my crib, bro.
Agent Looney, is this the video we've just displayed on the TV? Is this the video you showed the defendant?
Yes, sir.
And that's after watching that video is when you ask him the questions about how many times he shot her?
Yes, sir.
Move a copy of the video as the state's next exhibit, please. Agent Looney, in the investigation of this case, did you collect any shoes?
Yes, sir.
What type of shoes did you collect?
They were orange Nike.
And where were those shoes found?
In a shed on Highway. During the manhunt for Mr. Brown, they were found in a shed where he had been sighted.
And those shoes have been previously moved into evidence in this case?
Yes, sir.
And what color are they?
Orange.
And what color shoes is the defendant wearing in this video here?
They appear to be orange.
Okay, thank you. What was the location of the homicide in Louisiana?
1401 Iberville Street.
Okay. Those are my questions. I'll pass the witness.
Agent Looney, you were here for the entire trial in this case, right?
Yes, sir.
Okay. And there was no DNA on those shoes, were there?
No, sir.
Okay. And you don't know for sure, you testified that you didn't know for sure that Mr. Brown even had those shoes, right? Well, let me just ask it a different way. You don't know for sure that Mr. Brown had those shoes, that they're the same shoes, do you?
For sure, no, sir.
Okay, all right. And his DNA is not on them, right?
That's correct.
Who else has touched those shoes?
I touched them when I collected them.
With your bare hands?
No, sir. I had gloves on.
Okay.
I believe one of the shoes was used for one of the, I guess, search dogs to get a scent from. And then I would assume, I would assume that the shoes were handled by the lab.
Okay. So did you wear gloves to the trial?
No, sir.
Okay. You touched them at the trial, didn't you, on the
Yes,
witness
sir.
stand?
I did.
With your bare hands?
Yes, sir.
Okay. All right. And there's no DNA, so you can't testify that those shoes in that video are the same ones, and you can't link those to BJ Brown, can you?
No, sir.
Right. And during this interview, the excerpt of the interview that we didn't play at the trial, but you just played just now, I'm gonna go back through that, okay?
Yes, sir.
All right. You said you have a copy of that with you?
Yes, sir.
Okay. So when you told him that, and I'm looking at the bottom of page 132 there, sort of towards the bottom there, where you ask him, where you were getting his side of the story, right?
Yes, sir.
Okay. And you said that it looked like cold-blooded murder until you heard his side of the story, right?
Yes, sir.
Okay. So then it could just as easily, for all you know, been a crime of passion. At least it was about this argument over this money, right?
It could be. To me, just from what I saw in the video, a female lying there on the ground appeared injured. And from what that appeared to me, just based on what I saw in the video.
But then you changed when you got Mr. Brown's side of the story, though. Or at least you said it did.
Yeah, I mean, I was trying to be compassionate with and understanding with him during the interview based on what he had told me.
Because on page 133, you just said, like, you lost it. Those are your words to him, that he just lost it.
Are you referring to where I said, like, I mean, you said you lost it, right? Is that where you're referring to?
Yeah. Did he say that he lost it, or are those yours words?
He did.
Okay.
Yes, sir. On page 132, towards the middle, he responded to a question, yeah, and she was going to inaudible her life with my money, and I just lost it.
And you just lost it. Okay. Now, on the bottom of page 135, he says, you asked him, did you want to kill her? And he said no. Right?
Yes, sir, he did.
All right. He wanted the money. Right? And I think, without referring you to a specific page, I think during that, he said he didn't even know where he had shot her the times before that.
He did say that he had shot her in the leg.
Well, I'm sorry. After that, the second and third shot, he didn't know where that he'd shot her. Didn't you ask him that?
Yes, sir, and I believe you're correct.
And that's on 135 up there towards the top.
Yes, sir.
Okay. So it's fair to say you have no idea the nature of the circumstances surrounding this alleged crime in Louisiana, right? Other than what you've seen on video and what he told you.
That's correct, other than what he told me and what's on the video. Yes,
Okay. All right. Thank you.
Redirect.
Agent Looney, Mr. Spratt asked you if you were aware of the circumstances surrounding this homicide. You are aware of some of the circumstances, aren't you? Just based on your investigation?
The circumstances that
Circumstantial evidence.
that a homicide had occurred
Yeah.
in Louisiana prior to.
I mean, let's go through some of the circumstantial evidence. Were there any shell casings found in Houston County?
Yes, sir.
Did those shell casings match shell casings found at the homicide scene of Cassandra Jones?
They did.
Did the shoes that the defendant was wearing in this video we just watched appear to be the same color as the shoes found in Houston County?
They did.
Was the rifle linked to both the homicide in Louisiana and Houston County?
Yes, sir.
I'll pass the witness.
There were some items that were tested for DNA. You recall that in this trial?
Items were.
Some of those items had Mr. Brown's DNA on them, right?
Yes, sir.
But the gun didn't, did it?
No, sir.
All right. And you testified that you could not rule out that some wild animal drugged that gun into the creek, right?
Yes, sir.
All right. Because, I mean, he told you he dropped it in the woods, right?
He did say that.
Okay. So you have nothing to support I mean, it'd be fair to say for him to tell you I dropped it in the woods, and I mean, he told you where it was. So I mean, you got no DNA on that gun, right?
No, sir.
Okay. No DNA on the gun, no DNA on the shoes, right?
That's correct.
Okay. Thank you. And well, you don't have a positive ID that that's Mr. Brown in that video either, do you?
I did receive information that Miss Jones had from the detective when that phone call happened, that she had given a dying declaration and said Mr. Brown was the one that shot her.
Okay.
Redirect.
Agent Looney, you were asked about a positive ID about Mr. Brown and the homicide of Cassandra Jones.
Yes, sir.
You actually have a recording of a dying declaration, is that correct?
Yes, sir.
All right, I'd ask Mr. Etheridge to cue that up.
DJ Brown. It's not active.
Chapter 7.
Play it one more time.
DJ Brown. It's not active.
And Agent Looney, what did you observe in this video?
I observed an officer kneeling down near Miss Jones and then stand up and say BJ Brown.
And if you'll direct your attention to the screen, is there a name written as the suspect on this man's notebook?
Yes, sir.
And what's the name there?
BJ Brown.
I'll move a copy of this video as the state's next exhibit, please.
10.
Agent Looney, what you testified to was that you heard an officer say the name BJ Brown and then write that down, right? That's what you noticed about it?
Yes, sir.
Okay, you didn't notice who said the name first before the officer did you?
Based on the video, I could not tell who said the
Okay.
name.
Thank you.
Anything further? Thank you, Agent. You may step down. Crouch, you may call your next witness.
State goes Cleo Thomas. Ms. Thomas, will you state your full name, please?
Cleo Thomas,
And will you spell your first and last name?
Cleo Thomas, Thomas.
Thank you very much. Ms. Thomas, I noticed that you were with us and watched the trial in this case, is that correct?
I did.
And you're now here for the sentencing hearing?
Yes.
Do you live in Tennessee?
No,
Where did you travel from?
from Texas,
From Texas. Why have you traveled from Texas to be here?
because my niece was killed in New Orleans,
And who is your niece?
Cassandra Jones.
Cassandra Jones.
Mhm.
And again, tell us what your relationship with Cassandra Jones was?
Cassandra was my niece, but she was raised as my sister.
Your sister, okay. Where was Miss Jones living at the time of her death?
She was living in New Orleans, Louisiana.
And on June the 27th of 2022, what happened?
I received a phone call around 9:30 a.m. that she had been shot several times by BJ Brown.
Was that a hearsay, Your Honor?
That's what my phone call said.
I understand, thank you.
Sustained.
And after you received that phone call, Ms. Thomas, what did you do?
After trying to contain myself and on the phone with several family members, I then received another phone call from her.
And let me stop you right there. Don't testify to anything that somebody else told you.
Okay.
I'm just trying to walk through what you did that day.
Okay.
All right. So you can testify that you got a phone call.
I got a phone call.
All right. Where were you when you got the phone call?
I was at my place of residence.
At some point, did you drive to New Orleans?
I flew to Mississippi.
Okay.
I caught a flight and flew to Mississippi.
Why Mississippi?
Mississippi is home.
All right. And what happened when you got to Mississippi?
I got to Mississippi late that night. And I wasn't, of course, able to go to New Orleans by that time.
What happened next?
Well, unfortunately, as soon as I got off the airplane, I had to go straight to an emergency room in Mississippi because my brother was in ICU.
Okay. Did you see Miss Jones alive?
My last time seeing her was her lying in the bed, dead,
And what day was that on?
June 27th.
June 27th.
Yes.
And was that at the hospital?
She was at the hospital, yes.
And when you arrived, she had already passed?
I didn't make it. My family got there and they FaceTimed me.
Do you remember the day that of funeral services for Miss Jones?
It was July 2nd.
Did you help arrange the services?
I arranged the full service.
Why were you in charge of arranging the funeral services?
I've always taken care of things for her and the family.
Are you the closest of kin to Miss Cassandra Jones?
Besides her children, my mother and I.
And I noticed that you brought some papers with you today.
I did.
What are those papers?
His words is something I wanted to say to BJ Brown.
An impact statement?
An impact statement, yes.
Okay, if you would, please.
Okay. You are a piece of nothing who deserves to be referred to as a monster. You are one of the worst human beings on this planet. I'm sure by now, before I even said my name, you figured out who I was. That really should scare you, because you know I'm not going to give up fighting for justice for Cassandra. Just like you see me here today, supporting Officer Tiebor and his family for the heinous crime that you've inflicted upon them, let me reiterate to you that I'm not going to give up on getting justice for Cassandra. It is unfortunate that you were not raised to have a moral compass. So let me break that down to you, what I'm saying, because I don't feel like you're smart enough to know exactly what that means. I'm saying you're too ignorant and cruel to know how to judge right and wrong as it relates to the lifestyle you've chosen to live. I wish Cassandra had left you under that trashy bridge that you so deeply loved. I wish she had let you suffer when you had COVID. You had nothing, and you were nothing. She tried to teach you how to live a life of goodness. She provided you with shelter, food, transportation, and she even tried to help you find employment because she called me. How did you repay her for everything that she did for you? You murdered her in cold blood. Cassandra gave you love that you never, ever deserved. I am so glad that the last year of her life, she had become smart enough to move on from you before you murdered her. I hope not at a time in your life that you ever thought or that you think that you are a man, because you're not. You're nothing but a cowardly criminal. You have no regards for any living being on this planet, because only a coward shoots and runs. Only a coward sits there and looks as stupid as you're looking right about now, expecting leniency for the vicious crime you've inflicted upon Officer Tiebor and others. We thank God for his divine intervention, allowing Officer Tiebor to pull you over that night, because if he hadn't, who knows how many other lives you would have taken. Officer Tiebor, thank you so much for doing an outstanding job. BJ, the first time I met you, and I never meant to even say your name because it's not worthy, but the first time I met you, I knew I didn't like you. I only encountered your presence maybe 2 or 3 times, and each time your spirit exuded nothing but evil. I just hate Cassandra didn't automatically see through you as the rest of the family saw you. You robbed my family. You took a love from us that we could never get back. A loved one whose voice we can never hear again, ever again on this earth. A loved one whose physical presence can never be seen again. You took a mother, a grandmother, a child, a sister, a niece. You took our friend. You took a life that was never yours to take. And for that, I'll despise you forever. I pray the rest of your days are filled with misery, pain and suffering. I pray your family will feel the pain and void in their lives that you have inflicted upon us. I pray every day you're behind bars, your world grows smaller and smaller. You don't deserve to be in population. You don't deserve to see sunlight. You don't deserve to feel rain. You don't deserve happiness. For every soul you've taken, as you did to Cassandra, and every soul you've tried to take, like you did with Officer Tiebor, may you never again in your life have peace. I pray you never again in your lifetime have the opportunity nor the option to be released from prison. You belong behind bars until God Almighty calls you home. You are evil, wicked, immoral, vicious, corrupt, destructive. You're a demon. Every time you close your eyes, I pray you see Cassandra's beautiful face, because you know she was beautiful, to remind you of the scum that you are. I pray it disrupts your spirit constantly. May you rot in hell for eternity. Thank you, Judge Wolfe, prosecuting team, attorneys and staff, and the state of Tennessee for allowing our families an opportunity to see justice prevail.
Ms. Thomas, thank you for your testimony today. I'll pass the witness.
No questions, Your Honor.
Thank you, ma'am. You may step down and have a seat in the audience. Crouch, you may call your next witness.
Judge, that concludes the state's proof.
State has rested their proof, Mr. Spratt. Do you wish to offer any proof?
May I have a brief moment, Your Honor?
You may.
We have no proof, Your Honor.
I'll hear you in argument.
State waive opening.
Judge, Mr. Brown was convicted of
An A felony in count one. If we're looking at the indictment as it was tried, I believe it was a 5-count indictment at that time. The one that we actually used going to trial, as previous counts had been dismissed or removed. So count one being the attempted first-degree murder of Officer Tiebor. He is a range 1 offender on that charge. So to the state's notice, their amended notice that they provided in November for life without parole, I would argue that he should be sentenced as a range 1 offender. I would argue that that provision in that statute that was added as a matter of first impression is that provision is unconstitutional under the 8th Amendment. As Mr. Brown, what he's done here in Tennessee, what the jury found him guilty of here in Tennessee, it would be different if he shot a different type of citizen. And so for that reason, I would argue that it constitutes cruel and unusual punishment under the Constitution for him to be sentenced that way. So we would ask that he be sentenced in range 1, somewhere in the 15 to 25 year range in that sentence, understanding that it can't be a probated sentence. We all understand that. Counts 2 and 3, I believe those counts merge. One of those is a C felony, so I believe that would leave it with a C felony. I think State versus Fain, 451 Southwest 3rd, 362 at pages 368 to 370, talk about those 1324 counts A and B would merge. So I believe that leaves the court with a C conviction. That is mandatory consecutive. If the court finds, as the state's asked, that he's a range 2 offender with respect to C felony, under 3917 1324F, if he was going to be sentenced to that mandatory minimum for having a qualifying conviction, there's a procedure in 3917 1324F that had to be followed before he could be sentenced under G2 or H2. In this case, I think H2 would be the provision that the state would be seeking to travel under, assuming that those two convictions merged. Because it says there was no proof of a qualifying conviction presented to the trier of fact. So assuming that he's range 2 on that C felony conviction, that would leave the court somewhere between 6 to 10 mandatory consecutive to whatever he's sentenced for as far as count 1. So that being the case, we would ask that's going to have to be consecutive, and we're still asking that he be sentenced somewhere in the range 1 on count 1. And then counts 4 and 5, there was a nolo contendere plea entered during the trial to those counts, and those counts would merge. The count 5 was a misdemeanor possession of a weapon with a prior domestic violence conviction. Count 4 was the possession of the weapon with a prior drug conviction. So we would ask that any sentence, that would be a C felony conviction. And again, if he's range 2, as the state has asked, that is not mandatory consecutive, and we'd ask that that be made concurrent. And if sentenced under H2, potentially that those merge with the 39, 17, 13, 24 convictions. So, Your Honor, we're asking for a sentence somewhere in the 20 to 25 range on count 1, and somewhere 6 to 10 consecutive for counts 2 and 3, and then we're asking that count 4 and 5 merge and be ran concurrent. So for a sentence somewhere in the 30 to 35 year range. Thank you, Judge.
Judge, the state does stipulate that on count 1, the defendant would be range 1. The state's argument is that on the remaining counts, he is range 2, and we have submitted proof to substantiate that he's range 2. But the state's opinion is it doesn't really matter because the state legislature created 3913-202 subsection D for cases just like this. State legislature saw to it that a defendant who is convicted of an attempted first-degree murder of a law enforcement officer who's performing their official duties may be sentenced by the court to life without parole. Why? For cases just like this. This defendant murdered a woman on June 27th, Miss Cassandra Jones, on Iberville Street in New Orleans. He murdered her in cold blood on video, confessed to it, corroborating evidence of that murder. He gets in his car and drives to Houston County, Tennessee, where the officer, in performing his duties, pulled him over in an ordinary traffic stop and was greeted by the defendant getting out of his vehicle with an AR-15 rifle and firing 14 rounds at him. Why did the legislature create such an enhanced punishment against a law enforcement officer? Because they are engaging in duties that put their life at risk. And this is an exact case of why this statute was passed, dealing with a dangerous felony who just multiple prior felonies that Mr. Brown has been convicted of. And then he murders his ex-girlfriend and tries to escape and avoid his jurisdiction and flees to the state of Tennessee, where he is encountered by Officer Tiebor. So consecutive sentencing percentages, it's the state's opinion that none of that should matter, because in this case, we are asking, as did Ms. Thomas, for the court to show no leniency for a man who deserves no leniency.
All right, well, there are a number of exhibits, and this court is of the opinion that sentencing considerations must be followed that are set forth in our Tennessee Code. And I'm required to abide by those. And I will just simply, for the record, recite those so that it's clear that I am adhering to those guidelines that our state legislature has adopted. 4035-102 sets forth the purpose of our sentencing laws. And those are that every defendant should be punished by the imposition of a sentence justly deserved in relation to the seriousness of the offense. Chapter is to assure the fair and consistent treatment of all defendants by eliminating unjustified disparity in sentencing and providing a fair sense of predictability in the criminal law and its sanctions. Punishment shall be imposed to prevent crime and promote respect for the law. By A, providing an effective general deterrent to those likely to violate the criminal laws of the state. B, restraining defendants with lengthy history of criminal conduct. C, encouraging effective rehabilitation of those defendants where reasonably feasible by promoting the use of alternative sentencing and correctional programs that elicit voluntary cooperation of defendants and encouraging restitution to victims where appropriate. Sentencing should include all considerations respecting race, gender, creed, religion, national origin, and social status of the individual. In recognition of the state's prison capacities and the funds to build and maintain them are limited, convicted felons committing the most severe offenses, possessing criminal histories, evincing a clear disregard for the laws and morals of society, and evincing failure of past efforts at rehabilitation shall be given first priority regarding sentencing involving incarceration. And the defendant who does not fall within the parameters of what I just read and who's especially mitigated and so forth should be considered a favorable candidate for alternative sentencing. That has no application in this particular case. Everything I've read up to that point is almost spot on for the case that we have and the court's consideration in this particular case. In sentencing considerations, 4035-103, to implement the purposes of this chapter, which I just touched on, the sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrence to others likely to commit similar offenses. Or measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. Those are really considerations which the statute gives you when you have to decide whether or not incarcerating someone is or is not an option. In this case, there is no option regarding that. The sentence imposed should be no greater than that deserved for the offense committed. Inequalities in sentences that are unrelated to a purpose of this chapter should be avoided. The sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. The potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining a sentence alternative. That has no application in this case. Neither does the next one, which has, we're encouraged as trial judges to use alternatives to incarceration. And number 7 of that statute is available community-based alternatives. None of those factors have any consideration. First thing the court is required to do then is to determine whether or not the person is a standard offender or a multiple offender. And I think he's a range 1 offender as to count 1, and he is a range 2 offender as to count 2. So having classified and of course in count 3, it would seem to me that he would be a range 2 offender as well as that for class or count 3. And I believe that counts 2 and 3 would merge because they both are basically the same offense, just in different classifications. So then looking at the other factors that the court is required to consider, neither side has submitted any mitigating or enhancement factors other than what's been argued in court. There was no formal statement of mitigating or enhancement factors that the court has determined, at least that I saw in the pre-sentence report or in the court file. If I'm wrong, someone please let me know. But in any event, I am required to consider those factors, and 4035-113 sets forth the mitigating factors. And I have reviewed each one of those. For example, the defendant's criminal conduct neither caused nor threatened serious bodily injury clearly has no application. The defendant acted under strong provocation. I don't find that there to be, under the facts in this case, any provocation whatsoever. Count 3, substantial grounds exist tending to excuse or justify his criminal conduct of failing to establish a defense. There's no application in this case. And again, I've reviewed each one of those without going through them in detail. None of those mitigating factors appear to have any application in this case whatsoever. So then I move to 4035-114, which sets forth the enhancement provisions, enhancement factors. 1, the defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. Pre-sentence report sets forth a great number of these offenses in which certified copies of at least 3 felonies have been submitted rather. And there are drug offenses, there are resisting arrest charges, there are simple assault charges, there are theft charges, there is a burglary charge, theft of stolen property, possession of stolen property, a domestic violence charge, which is certainly enlightening in view of what's happened in this case, another charge of resisting arrest, a charge of disturbing the peace, vandalism, drug paraphernalia, resisting arrest, and vandalism. So the court finds that that enhancement factor clearly applies. He does have a long history of criminal convictions in addition to what was necessary to establish the appropriate range. Number 2 does not apply. Number 3 does not apply. Number 4 does not apply. Number 5, the defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. Doesn't really apply in this particular situation. Number 6, the personal injuries inflicted upon or the amount of damage to property sustained by or taken from the victim are particularly great. In this court's opinion, that does apply. I realize that it's an attempted first-degree murder, but you can have an attempted first-degree murder without inflicting the type of injuries that were inflicted on this officer in this particular case. He will carry with him the scars and the remnants from the shells for the foreseeable future, perhaps for the rest of his life. And I believe that this was a very serious personal injury, that striking his clavicle, and I refer to the State versus Wilbert Brazel, where that particular case was many years ago, but there was a bullet fired that struck a woman's clavicle, and it was a .22, but it severed her jugular and she bled to death. So the officer was very lucky that he was not suffered the same kind of thing with the type of injury. I do not find that number 7 applies. Number 8, the defendant before trial or sentencing failed to comply with the conditions of a sentence involving release in the community. Clearly, there was some evidence that he was on probation at the time. He certainly had probation in many other instances. Although I don't believe that the pre-sentence report showed that there was any violations of probation. There was reference made to a violation of probation warrant that might have been outstanding at the time, but he was on probation at the time that, from that last conviction at the time that this occurred. So while that may have some application, I'm not assigning that very much weight. He possessed or employed a firearm, explosive device, or other deadly weapon during the commission of the offense, and of course he did. And that was, I think, a part of that, of the requirement of, or part of the elements of the charge of attempted first-degree murder. So I don't believe I can consider that as an enhancement factor. Number 10, he had no hesitation about committing a crime when the risk to human life was high. That does apply. And clearly, all you have to do is watch the video in this particular case. The officer's body cam video, the officer's dash cam video, the video from the security cameras of the commercial property that were there. And the defendant in this case jumped from his car and firing off 14 rounds at the deputy and clearly had no hesitation about doing so when he could have very easily have killed him. Don't find that number 11 applies, because that one says the felony resulted in death or serious bodily injury or involved the threat of death or serious bodily injury to another person, and the defendant had been previously convicted of a felony that resulted in death or serious bodily injury. He was not convicted of the homicide in Louisiana at the time that this occurred. To my knowledge, he had not yet been convicted. During the commission of the offense, he intentionally inflicted serious bodily injury upon another person. The actions of the defendant resulted in death or serious bodily injury to a victim or person other than the intended victim. And again, I think that applies, but I believe that would have to also be a portion of the crime itself, attempted first-degree murder. In any event, I think it does apply, although I will not assign very much weight to it. And again, number 13, when the felony was committed, he was, in my opinion, released on probation at the time based upon the prior convictions. That was the status that he had. And do not believe that there was any other of the enhancement factors that would have been applicable except for number 19. If the defendant is convicted of an offense of aggravated assault under 3913-102, the victim of the aggravated assault is a law enforcement officer and so forth, that would not really apply because he was convicted of attempted first-degree murder of the officer rather than just aggravated assault. So those are the aggravating factors that I found are applicable in this case. And based upon all of those factors, I have considered the evidence at the trial itself. I've considered the evidence that has been presented in the form of the pre-sentence report. I have considered the evidence that had been offered at the sentencing hearing. I've also considered my observations of the defendant in the courtroom during the sentencing hearing. And it is my opinion that based upon all of those factors, that as to count one, that the court does find that the defendant should be sentenced to life without the possibility of parole as the appropriate sentence, the only appropriate sentence that this court is of the opinion for several reasons, not the least of which is that clearly having murdered an individual by the proof here in this court that has been presented in the state of Louisiana, he fled the state of Louisiana, came to the state of Tennessee, to Houston County, Tennessee, and had no hesitation about attempting to murder a police officer who had stopped him. And that indicates to me that there is no possibility of rehabilitation of Mr. Brown, and that the only appropriate sentence, when I look at the sentencing guidelines and considerations, which I have stated in the considerations as that the sentence should be necessary to protect society by restraining a defendant who has a history of criminal conduct. It is necessary to avoid depreciating the seriousness of the offense, and it is particularly suited to be a deterrent to others, and measures less restrictive. Those are all for whether or not he should be confined, but clearly I think all of those sentencing considerations also factor into whether or not I should impose life without parole. The purposes of the chapter are to provide an effective general deterrent to those likely to violate the criminal laws of the state, and I believe he is a person such as that. It is necessary to restrain a defendant with a lengthy history of criminal conduct, and it is this court's opinion that that is the appropriate sentence for count one. In count two, I find that he is classified as a range 2 offender, therefore his sentence is 4 years to 8 years is the range, and I sentence him to 8 years in the Tennessee Department of Corrections. And count that will be for count 2. Count 3, I believe, would merge, but nonetheless, it is I think the sentence would be 6 to 12, and I'm going to impose another 8-year sentence in that particular situation. Those two will merge together for an effective 8-year sentence, and they will run concurrently with the life without parole. And then my understanding is that I'm sentencing him on the count 4, which was he pled to during the trial on the possession of a weapon during
Possession of a weapon with intent to go on was
count 5.
count 4 was dismissed.
Count 4 was dismissed, and count 5 is a Class A misdemeanor, and it will be sentenced to 11 months to 29 days in the county jail. That is the judgment of the court in this case. Are there any?
Judge,
I'm looking at the copy of the indictment that we had.
we agreed to renumber the indictment before trial.
Right.
So the court will need to sentence him on counts 4, 5. Count 4 is. Count 4 is possession of a weapon by a convicted felon, and 5 is.
Hold on a second. I have a copy. What I've been looking at is a copy of the modified indictment that we presented to the jury. Count 5
Is the unlawful possession of a weapon having been convicted of a domestic assault.
All right. And that is a Class C felony.
That's an 8 misdemeanor, Judge, and the 4th count was the
Possession of a weapon by a prior drug felon. So I do think those two would merge.
Let me take a short recess. I want to make sure of that. Let me see counsel in chambers. We'll take a short recess. Okay, I want to go back on the record with this sentencing and conclude the sentencing portion. I have, looking at counts 2 and 3, those two, as I've said before, would merge. And by statute, those two would have to be running consecutively to count 1. So the sentence in count 1 is life without parole. The sentences that I've imposed in counts 4 and 5, I'm sorry, counts 2 and 3 are going to run consecutively to count 1. In count 4 of the indictment, he's charged with a Class C felony, that is having been possessed of, been previously convicted of a felony drug offense. He was unlawfully possessed of a firearm. He entered a plea to that during the trial, and for that reason, I will impose a sentence because he is classified as a range 2 offender. I classify him as a range 2 for that particular count and sentence him to 8 years, Tennessee Department of Corrections. Count 5 is Class A misdemeanor, and I sentence him to 11 months and 29 days in the county jail. Those two will merge together. And that sentence on counts 4 and 5 will run concurrently with count 1 of the indictment. So that should conclude all the considerations regarding the sentencing. I will state for the record that the factors that I have eliminated, or that I have identified rather, as to why, how, and why I reached the sentencing that I did, I am not sentencing Mr. Brown for the offense that he committed in the state of Louisiana. I will leave that to the state of Louisiana. And while certainly Ms. Thomas's powerful victim impact statement related to that particular situation, it did not have any impact on the court's decision-making. And Ms. Thomas, I want you to understand that's only because I cannot consider what you would say about your niece or your sister's situation in determining the sentence for the crime here. The crime here was the attempted murder of a police officer in Tennessee, and that is why I have sentenced him to those other considerations regarding Ms. Cassandra's death in the state of Louisiana were admitted and were considered by me on the overall consideration of the appropriate sentence, but they were not the basis for my final determination. I just wanted to make that clear on the record. All right, then Mr. Brown is sentenced to life without parole on count 1, and the other sentences as imposed, he's remanded to the custody of the Tennessee Department of Corrections to begin serving that sentence.